the IBC would undertake its processes under Article 257(4). We of the view that the 3 months period would equally be used by the IBC when undertaking the verification of signatures to grant the public sufficient time to confirm whether or not they had appended their signatures in support of the amendment bill. Such public participation was made to look like it would be so difficult to attain. In our view, we have the view that, as it was in the administrative procedures, that the IBC should provide a process where the public get to confirm indeed to the IBC that if they've appended or they were in support of the bill. They should provide a window period within the 3 months period envisaged in the law for a complaint mechanism, as well as a mechanism to resolve those complaints when they arose. In the instant case, the IBC provided in its administrative procedures that were indeed found unlawful that the public had 22 days through which to verify whether or not they were in support and had provided their signature in support of the bill. However, IBC published the names of those people in its website and provided for 5 days period through which members of the public would indeed confirm to the IBC whether they are in support of the bill or not, and also the 5 days period was also to be a complaint period. The question therefore is, did IBC have a simple, accessible, and transparent processes for signature verification that would enhance public participation in the process as envisaged under Article 257(4) and 5? The answer is no. The process was not simple, how the public would get to participate and verify their signatures, because when you go to the IBC website, and this information is on record, IBC provided a PDF scan. One could not use or search their name or ID number on the website because it was a PDF scan. Even I, as an advocate, we had to spend voluminous time going through the list to indeed look through the list and understand what the IBC was doing. Number two, the IBC put this information on its website. Was that accessible to majority of Kenyans? Satisfactorily not. The website stated that the notice to make complaints would be there for 2 weeks. However, the IBC shortened the period to 5 days. How many Kenyans have access to website and internet in this country? How many are able to go through, have internet, access it, and be able to complain to the IBC that their names are erroneously put or they did not provide their signatures? How many? Very few can. Was it verifiable? Was it accountable? How the IBC undertook this? In the absence of a legal framework, in the absence of lawful guidelines and regulations, even we are clear that it also breached its own administrative procedures, who was the IBC accountable? Can we therefore say that there was public participation in the verification and certification processes as envisaged under Article 257(4) and 5 of the Constitution? The answer would be no. On the second aspect of public participation, the question then would be, how should it look upon the verification and the certification? On this one, I agree with the submission that was made by Mr. Ngumbo yesterday, that public participation would arise on 3 instances upon the bill being certified as being supported by 1 million registered voters. The first The first instance would be at the county assemblies. The county assemblies have an obligation under Article 196(1) of the Constitution to undertake public participation in its legislative mandate. So at the point it is considering the bill, of course, it is envisaged that it would use and would avail the bill for public participation. The question would be, was that done? Public participation is a factual issue. It is an issue that ought to be proven through evidence. The county assemblies are parties in this suit. Unfortunately, they did not participate in the proceedings, and therefore, being a factual issue, it is conclusively to say that there was no public participation at the county assemblies in absence of the requisite evidence. The second instance when public participation would be envisaged is at Parliament, when Parliament is considering the amendment in terms of Article 118 of the Constitution. And equally, at the very end of the process, when the IBC is undertaking the referendum, that obligation would be in form of civic education on sensitizing the members of the public on the content of the BBI draft bill or any draft bill. We therefore submit to that end that there is a need for legal framework to guide the processes on public participation to ensure that indeed it complies with the IBC constitutional mandate and obligation, especially while undertaking its verification, certification, and referendum processes. Such a legal framework is very important because it would make the process accountable to the law and therefore be able to ensure that it complies with the Constitution or any other legal framework. Thirdly, we submit that without a legal framework, there exist so many gaps. And one of that gaps is what the Chief Justice did identify: public participation. How is it supposed to be done? Had we had a legal framework, it would be very easy for us to go back to that legal framework and seek whether or not the IBC complied with the law. Indeed, Chief Justice, there have been attempts made by Parliament to legislate on these processes. On record, you'll find 2 bills that are currently pending through Parliament. A casual reading of the 2 bills would provide that indeed at Section 8 and at Section 4, both of the bills provide for public participation. So there is need for a legal framework. There is need for a legal framework to guide how the IBC undertakes its mandate under Article 257, 4, and 5 of the Constitution. Having said that, and having finished what the 2 issues are, I will therefore urge the court not to disturb the order that was issued by the Court of Appeal, Order number 14, that issued a permanent injunction restraining the IBC from undertaking any of the processes under Article 257(4)(5). That order has not been appealed, and the issue of an existing legal framework has also not been appealed in this court. We therefore urge the court to affirm the Court of Appeal findings and we dismiss the appeals. We also associate ourselves with the submissions made by the third apparent on the issue of quorum in this court. And that will be all from us. Thank you. I will donate the remaining minutes to the 7th and the 8th respondent. Thank you, Chief Justice.
The donation should be to the 11th and 12th?
Yes.
Thank you very much for your submissions. We will now hear from the 11 and 12 respondents.
Malady, may I start? Sorry. Malady, may I start?
Proceed.
Thank you so much. It's my pleasure to appear before you, my Lady Chief Justice and President of the Supreme Court, and my lords, my ladies, justices of the Supreme Court. My name is Ongoya. I appear together with Mr. Ogada for the 11th and 12th respondents in the appeal. In our 55 minutes, I would endeavor to use 30 minutes and reserve 25 minutes for my colleague, Mr. Ogada, to deal with the remaining issues that we have organized ourselves to deal with. In terms of filings, I would invite you, in addition to considering the petition number 402 that was before the High Court, to also consider the grounds of objection dated 18th October 2021, as well as our written submissions dated 9th of December 2021, and our case digest and bundle of authorities appearing in 3 volumes dated 22nd December 2021. In the interest of time, I would seek to just draw the court's attention to the following matters that I consider fundamental and overarching as you read those voluminous submissions and authorities. First, my lords, my ladies, we will remind each other that we have a history as a country, and that history has taught us some lessons, some of them very fundamental lessons. Fortunately for us, a bulk of the council appearing at this podium, and my lords, my ladies, seeking to make this monumental determination, you have been a part of that history as citizens of this country. And that we should never let down the generations that will follow us by delivering a verdict that may make generations to come to have to live through some of the pains we have lived through as a country. Part of those pains were captured by retired Justice Aaron Gitonga Ringera in the case of Njoya versus the Attorney General, which you have been referred to, and which I'll implore you to read and have inform your verdict. And to call you to consider that history, my ladies, my lords, is not to invite you to engage in extra-legal considerations. Parliament has done the same thing in Section 3 of the Supreme Court Act. It has asked you that at all times you must endeavor to give us an authoritative and impartial interpretation of this Constitution, and in so doing, to develop jurisprudence that respects that history, so that attempts at clawing back on the Constitution that appear innocuous sometimes, you must be hawk-eyed to see them for what they are, particularly if they are dangerous rodents. Because again, we know that a dangerous rodent will chip away bit by bit, but eventually bring down huge infrastructure. So, in terms of the development of the dispute now before you, I would ask my ladies and my lords to remember that before this dispute was determined by the High Court and eventually the Court of Appeal, there were 2 advisory opinions that were sought before this court by the county assemblies of Nandi and Kericho and the county governor of Makueni. My lords, my ladies, in your wisdom, and we respect that, you directed that you will not exercise jurisdiction over those opinions to allow this dispute to go through the formal dispute processing mechanisms from the High Court up to the level it has reached. I say that was wise because This dispute has therefore had a benefit of the contribution of dozens of lawyers and a number of persons not formally schooled in legal training, and it has had the benefit of reasoning by a dozen superior court judges, 5 in the High Court and 7 in the Court of Appeal. Without suggesting that you are bound by the decisions of the High Court or the Court of Appeal, I submit that a product of the minds of a dozen superior court justices is not for dismissal by a wave of the hand. It must be taken seriously, and an element of deference must be given to it, so that any disagreement with it must be after serious soul-searching and serious reflections. So that this court, I submit respectfully, should approach the reasoning of the 5 High Court judges and the 7 Court of Appeal judges with a substantial measure of deference. I submit that it's a sound principle of appellate advocacy and appellate judicial decision-making processes that when we're dealing with a second appeal, as is the case here, it is not appropriate to reintroduce and reopen for consideration concurrent factual findings of the Court of First Instance, in this case the High Court, and the Court of First Appeal, in this case the Court of Appeal. If we take that principle in consideration, we then must dispose of some 2 matters with a measure of ease, my lords, my ladies. As a matter of fact, the High Court looked at the to public participation in the process now before you. The Court of Appeal, as a court of first appeal, had an obligation, and it re-evaluated the material that was before the High Court and came to its own conclusion, and the conclusion was insufficiency of public participation as a matter of fact. I submit respectfully that it is not open for counsel appearing before you or for this court in its decision-making process to reopen that factual issue as to whether there was, in fact, sufficient public participation. As a matter of fact, the High Court, as a court of first instance, and the Court of Appeal exercising that jurisdiction I've alluded to, re-evaluated the question of who initiated this process. And it came to the conclusion that it was the President of the Republic of Kenya who initiated this process. It is not open for this court to reopen that question of fact. And that, therefore, will dispose of a number of questions that have preoccupied the minds of many counsel who have appeared before you today. Having said that, allow me to come to the specific issue that was introduced in the judicial system by the 11th and the 12th respondents now before you, that's Mr. Juma and Mr. Ogolla, which led to the order at paragraph 495A, Roman 12 of the lead judgment of Justice Musinga, in the terms that the second schedule to the Constitution of Kenya Amendment Bill, and these words are important, my lords, my ladies, insofar as it purports to predetermine the allocation of proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its functions of constituency delimitation, is unconstitutional, with one dissent from Lady Justice C. Charlie. That qualification of what was declared unconstitutional is important, and I emphasize it because of the submissions by my very senior learned colleague, Mr. Karori, the day before yesterday. The court, in fact, found that the provision of the Constitution relating to the number of constituencies in Kenya is amendable without necessarily taking recourse to the four-tier process that the court identified. What the court had an issue with was the allocation of the proposed additional 70 constituencies and the direction of the IEBC on its function of constituency delimitation. When you retire to interrogate whether the court was right or wrong on this question, I was warned that when we tell you when you retire, a lot of laymen think that you'll have to wait for your retirement age before you return here with a verdict. So I use that word advisedly in the technical sense of it. It's important for my lords, my ladies, to ask yourself this question: how did the court of first instance reach this conclusion, and how did the court of first appeal confirm this conclusion? A good starting point for me is what the judgment of the court of first instance says at paragraph 469. It's important that you reflect on what that judgment says at 469. And that will be so because the court has to answer the question, did that court use the correct methodology to reach this conclusion? Did it use the correct methods of interpretation? The court said, the stable canon of principles of interpretation of the Constitution, which have emerged as outlined above, are dictated by our constitutional text. So the court took into account the reading of the text. Heavy weather has been made on the argument that this court abandoned the text completely and converted itself into a philosophical tribunal. No, the court expressly said that it is taking account of our text. Secondly, the structure of that text. Thirdly, the nature of that text, which the court defines to mean the fact that it is a transformative charter. Next, our history, which both the Constitution at Articles 259 and 10 and statute, the Supreme Court Act, the very act that now directs this court, and binding precedents and the context. The court is telling us that it is taking on board all material parameters required for the interpretation of this Constitution for purposes of reaching that verdict. I submit, respectfully, my lords, that to depart from that verdict, or to invite you to depart from that verdict, the petitioners before you appealing, at least the first and second appellants, had an obligation to demonstrate to you that any of those parameters was an irrelevant consideration. They have not done that. They had an obligation to show you that there was another relevant consideration that those judges were under an obligation to take into account, which they failed to take into account. They have not done that. That then takes us to paragraph 681 of the judgment of the Court of First Instance, which is the High Court. And if you look at paragraph 681, the court engaged in a detailed analysis of the history of Article 89 of the Constitution, which deals with delimitation of constituency boundaries. And the court set out 6 elements in the second schedule 6 elements that make that second schedule violative of Article 89 of the Constitution. 6 elements. I'll not read them word for word, but you'll see 6 elements. If you go to paragraph 683 of the judgment, the courts then endeavor to elaborate on each of the 6 elements. I'm submitting, my lords and my ladies, that the High Court, as a court of first instance, used a scientific method of arriving at the conclusion that it arrived at. The jurisprudence, as I know it, is not just enough for you as a court to say, well, on my part, I would have arrived at a different conclusion, and thereby substitute the finding of the High Court with another finding. You would have an obligation to tell us which part of the history as stated by the High Court in those paragraphs is a wrong representation of our history. But even the appellants have endeavored to point at one. Let me just highlight one example. The court said that a constituency is a unit of resource allocation in this country. The court said so. And the court said, to the extent that a constituency is a unit of resource allocation, the determination of distribution of constituencies has an effect on equity or the skewed nature of distribution of resources. And the court therefore said, to have a scientific and equitable distribution of resources, we must have a scientific distribution of constituencies. The court therefore found that since IEBC in Article 89 is subject to a science of delimitation of boundaries that eventually gives us the placement of constituencies in specific geographical areas, it was not open for us to abandon that and determine constituencies politically, to say it is just a political issue, as my learned colleague, Mr. Karori, has purported to submit before you. Again, I ask the question, which part of that method of arriving at that decision violates Article 259 on the proper principles of interpretation and Section 3 of the statute enabling this court, the Supreme Court Act, that gives this court a scientific formula of reaching scientific jurisprudence, can you possibly fault? I submit there is none that you can possibly fault. So we are told that if you predetermine the allocation of the constituency per county politically, and tell the IEBC, no, your role is now limited to just telling us where this constituency is in Nyamira, where this constituency is in Vihiga, where this constituency is in Samburu, you are hamstringing it from applying the complete methodology set out in Article 89, and to that extent, you are beginning to plant a seed of inequity. You're dealing with a country that has a clear history of inequity. So the court is using the correct formula and saying, no, let the IEBC apply its mandate under Article 89. Use the correct formula, knowing that the IEBC's word in Article 89 is not final. If the IEBC makes an error, there is an avenue available for a disturbed litigant to come to court and seek judicial review under Article 89(10) of the Constitution. The court is saying one of the elements that makes the second schedule unconstitutional is that even that right to come to court and complain by judicial review is taken away. How can we fault the court for such a scientific and principled approach to the resolution of the dispute that was before it? I submit respectfully, my lords, my ladies, that if we apply our minds objectively to the manner in which the High Court reached that verdict and the reasoning that the Court of Appeal engaged in confirming that finding, we will affirm We reaffirm that finding. We will not disturb it. But more importantly for me, when you retire to have a conversation on this issue, you may also need to ask yourself the question, looking at the material presented before you in terms of the establishment of the task force, the BBI task force, the BBI steering committee, the various reports that they generated, and the publication of this bill, at what stage did the second schedule come into being? That's one question, my lord, my ladies, you will never run away from. Because when you're told there was public participation in even the generation of that schedule, you'll have to answer that question. At what point did the second schedule come in? You will notice that the second schedule was what the High Court judges eventually described as an endeavor to amend the Constitution and fundamentally alter it through stealth, because it's a latecomer in the whole process after the hitherto processes have all been exhausted without anyone telling us. So who was this telling us that Siaya County required this number of constituencies? Who was that among the participating public? To that extent, my lords, my ladies, and so as to invite my learned colleague to engage you in far conceptual matters that are of great impact in this litigation, I submit that once you look at that history, once you look at the relevant materials the judges took into consideration, once you consider Kenya's history as captured in various stages of review of our Constitution, at least in the latter years, partly captured in the Njoya decision and partly captured in the commission reports, including the Kregler report that you have been referred to in depth. And once you look at the BBI process itself as it flew, you will come to the inevitable conclusion that to the extent that the second schedule of that bill purported to predetermine the allocation of the proposed constituencies to respective counties and direct the IEBC on how to delimit those constituencies, that was unconstitutional. But there's an important question that one of my lords raised yesterday, and I have to respond to it. When you go to the processing of petition number 402 before the High Court, I want you to investigate the question, what position did the IEBC take on that position? The IEBC, throughout the processing of this dispute, up to the time it comes before you, has never contested this position of the 11th and 12th respondents. Never contested that position, that this second schedule is unconstitutional. Number one, I want to look at the appeal that the IEBC filed at the Court of Appeal. They did not challenge this position by the High Court. Number two, I want you to look at the appeal that that was filed on behalf of the IEBC before you. They have not challenged this concurrent finding of law by the High Court and the Court of Appeal. Which brings me to the oral representation by my very good teacher and mentor, Professor Githu Muigai, that the IEBC's position now orally at this podium is that Article 89 of the Constitution does not amount to a basic structure. First, Professor Githu Muigai told us that to him, the word basic structure means entrenched provisions. And he traced those entrenched provisions in Article 255(1). You realize that even if you use that test by Professor Githu Muigai, the independence of the judiciary and the independence of constitutional commissions, which includes the IEBC, would become part of the entrenched provisions. So that applying his own test, Article 89 would become an entrenched position, which he equalizes in terms of effect to a basic structure. And therefore, to the extent that the court at the first instance and at the second instance called it as much, we cannot fault the court for doing that. But more importantly for me, the IEBC must be taken from its word and conduct in the respective courts by its formal findings that it has all along been satisfied by the position taken by the 11th and 12th respondents on the first part, and the position taken by the High Court and the Court of Appeal on the constitutionality of the second schedule of the Constitution. I urge you to dismiss the petition of appeal by the Attorney General. I have reason that the Attorney General in this matter was mourning louder than the bereaved, the IEBCs at that juncture, to invite my colleague, Mr. Ogada, to do duty regarding the other conceptual issues that are relevant to this finding.
Your Ladyship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, Justices of the Supreme Court, my name is Evans Ogada. As a citizen of Kenya, as an advocate of the High Court, I am here to execute duty on behalf of the 11th and 12th respondents, and I will leave to my primary function as an advocate, and that is to speak the constitutional truth and speak the constitutional truth to power. The Constitution, and any constitution for that matter, in its formative force, varies from country to country and from time to time. The French can possibly claim to have been the French and the monarchies and the military dictatorships and assorted republics. The Germans can claim to have been different people under the Kaiser, under the Weimar Republic, under the Third Reich, and under the Federal Republic. For polyglotted societies such as Kenya, and those riven by religious divisions and bleeding memories of civil strife and war, our Constitution assumes an important function. And this function is that the Constitution serves as a uniting force, the only principle of order that there may be, that there may be no other shared moral or social vision other than that of the Constitution. And it's only the Constitution that unites these eclectic societies that we tried to cobble in what Professor P.L.O. Lumumba calls the Berlinian construct, the nation state. The Constitution as a product of the people being the authoritarian creator, the emanator of the Constitution, bears special significance in Kenya in the 21st century. The solemnity of the occasion today for the Supreme Court cannot be overemphasized. The duty of this court cannot be overemphasized. Former Chief Justice of Malawi, Andrew K.C. Nyirenda, in course number 19 of 2020, says that it is the duty of any court to safeguard the purity of the law and to sanction any evasion, any erosion of violation. That is the duty of the Supreme Court of Kenya. That yours is to ensure that constitutionalism, the rule of law, is maintained and is reified. And what do we mean by constitutionalism? Constitutionalism means that government must be hedged in substantive limits, that there is what is permissible under a constitutional order, even if the perfect majority are against it, even if it upsets majoritarian interests. Alicia Ngoya has spoken about a history, the history of our constitutional journey. The most overlooked part of the Constitution is the preamble. Paragraph 3 of that preamble talks of honoring those who heroically struggled to bring freedom and justice to our land. Justice Muhammad Ibrahim, the victims of the Nyayo Chambers, Nyayo Torture Chambers, Gitobu Imanyara, James Agri Orengo, Maina Kenyati, Baby Pendo, clobbered to death while carried by her mother. These are the matters that we have to remember when you exercise your solemn role in determining this petition. The thrust of the operative legitimacy by the Attorney General and the proponents of the BBI bill is to the effect that the whole exercise was an exercise of amendment. My brother Nelson Harvey and Mutuma referred to you dictionary of definitions for the term amendment. I want to look at the term amendment, Justice Wanjala, from its etymological hasin, the origin of the word. The origin of the word is from the Latin phrase emendere, E-M-E-N-D-E-R-E, which means to correct, to modify a system. An amendment has to operate within a certain parameters of an existing constitution. With regards to boundary delimitation, Article 89(1) identifies 290 units, representative units, and canonizes them as constituencies. Now, these constituencies have been divided within 580,367 square kilometers that geographically is called Kenya. That geographical area enjoys constitutional and international law significance. Under Article 5 of the Constitution of Kenya, the territory is protected. Under Article 2.4 of the UN Charter, that territory is protected. Professor Wanjala, Justice Wanjala, under the principle of uti possidetis juris, international law, we are bound by customary international law to respect those boundaries as bequeathed to us at independence. The Attorney General has two offices within his department, the Kenya International Boundaries Office and the Treaty Division. At independence, when the colonialist was departing, there are certain instruments that were granted to us that clearly behove us to respect this territory. Where am I going with this story? That when the Attorney General, through my learned senior, Mr. Karori, tell us that they are going to create constituencies, that the people can create constituencies outside these parameters, the 580,000 or so square kilometers. The question is this: where is this territory outside 580,000 square kilometers that we are going to create these new constituencies from? Are we going to create them in the air? Are we going to create them below ground? Are we going to create them in the sea? Reductio ad absurdum. It doesn't make sense. The upshot of our argument is this: that any creation of new constituencies can only happen within the demarcated 580,000 square kilometers. And that's where the IEBC comes in. Its role in Article 88 and 89 is to conduct an exercise in delimitation. The Attorney General, through Mr. Karori, waxed lyrical in the defense of the impugned bill, stating that the 70 constituencies were aimed at ensuring fairness and that the allocation of the 70 constituencies was a political role. I shuddered when I heard of the term fairness. the question that the Attorney General must answer before this court is, who determined what is fair? What are these parameters of fairness? And implicit in that argument is the majoritarian representations of the schedules to the BBI bill represents fairness. If we can take it for face value, Nairobi has 12 intended constituencies under the BBI bill. What are you telling my brother from Samburu, Leisagor, Naisula from Samburu? What are you telling Muikali from Machakos? That fairness is synonymous with numbers? Hell no. The Constitution of 2010 has departed from majoritarian premises. And we are saying that we have to be egalitarian. We have to cater for the minority. It is pro those who have been marginalized. And that is the statement of the Constitution 2010. Let us look at the manner in which this bill was originated. It was the position of Senior Counsel Kirago that the origin is hazy. The question is, from their own admission, if this origin was hazy, where did the people come in to prescribe the exact number, that is 70 constituencies? Was the poor peasant, the woman in the village in Yimbo Senge, consulted in terms of whether she wants a constituency? The people of North Horr constituency, it takes you 5 hours from one corner to another. Embakasi, Babu Owino's constituency, to the Uri's constituency, it takes about 10 minutes. Fairness. What are we talking about when we talk about fairness? What are the impugned provisions of this bill? I want to refer the Honorable Court to Section 10 and Section 74 of the BBI bill. What do these impugned provisions do? Number one, they purport to create 70 constituencies. Two, they direct the IBC to determine boundaries and to delimit 70 created constituencies to specific counties, leaving out others. They stipulate the time period within which the IBC must act. They stipulate to the IBC the criteria to be used. Sacrilege, heresy. The IEBC is an independent constitution, enjoying functional independence. And the Supreme Court has addressed itself time and again on the question of independence. I refer this court to the decision of matter of interim Independent Electoral Commission, advisory number 2 of 2011. I also refer this court to Communications Commission of Kenya and 5 others versus Royal Media, 2014 EKLR. The court spoke of independence, and I'll refer you to exactly what this court said. You cannot depart from that. For purposes of rule of law and for certainty, I beseech you to maintain the statement on constitutional commission independence. There was a position held here by Mr. Karori on behalf of the Attorney General that we are still in the conceptual mooring of 3 branches of government. May I correct that assertion loudly and clearly in the presence of my teacher sitting on the other side, Professor Ben Murumbi Sihanya, that we have since moved from the traditional understanding of government as 3 branches. We have moved from the trias political model, and with the commissions, the independent commissions coming in, that is argued, amongst others by Professor Sihanya, that we have a 4th arm of government, such that when Justice, the Deputy Chief Justice, and the Chief Justice represent the Supreme Court at the Judicial Service Commission as commissioners, their presence there is in an independent office, contradistinguished from the judiciary, where they sit as judges of the Supreme Court. Power contrary to contra-power, ambition contra ambition. That is the Montesquieu edict in terms of separation of powers. So that when the IBC is a beneficiary of separated power, its functional capacity under Article 88 and 89 must be respected, and without apologies. What is the mischief that was intended by the Constitution in terms of demarcation and delimitation? There are certain undergirding principles that were intended to be safeguarded. And these principles we have highlighted, and I refer the courts to Volume 3 of our Case Digest, from page 450 onwards. There's a scholarly article by a lady, Lisa Handley, giving a history of boundary delimitation from a comparative perspective. The history has been looked at by the High Court. The principles: impartiality, equality, representativeness, non-discrimination, transparency. I will address myself to the question of impartiality, because that is what concerns us with the IBC. The process of boundary delimitation is removed from the political organs, and the IEBC should shepherd the whole process and guide the people in terms of the whole process. Elisha Ngoye has gone through that process. I will not go through it. But if the people were to be aggrieved by the processes conducted by the IEBC in creating new constituencies, then we have a recourse to Article 8910. What this bill, in its purport, tries to do is to short-circuit the Constitution, to remove the ability of the people to seek redress from the judiciary. The manner in which they propose for this new creation of constituencies to come in is what we call in conceptual theory constitutional octroi. What is constitutional octroi? An imposition, a patrimonial way of creating a constitution. Contra a thesis to what we have under the Constitution 2010. Ours is a liberal democratic manner in which we generated our constitution. And it is important to know that the people, in terms of creating these new constituencies, must influence the role, must have an influensive role through public participation. Public participation is important for this reason, that conceptually, we are trying to take away imposition by politicians, and the people must qualitatively and quantitatively have an influence with regards to decisions that affect them. Constitutional octroi, as being suggested by the Attorney General, is a seeping, an insidious threat to constitutionalism. That should it be allowed, and bearing in mind our history, our constitutional history, we will be inviting the insidious tarantula effect, whereby politicians can creep in and massacre, butcher, murder the Constitution as we know it. It must be resisted. The judiciary as a negative legislator. A question was posed here in terms of the judicial role. The judiciary is a negative legislator, so that when the courts correct misgivings or errors in accordance to the Constitution, the judiciary becomes a negative legislator. It is a proper function for a Kelsenian court. So that this, not to be had the term political being bandied around here, this court should take safeguard and safety in the Indian case of the state of Rajasthan and others versus Union of India, 1977, where the Supreme Court of India, Bhagwati Jay, said that the constitution is a matter of politics. So that Justice Ibrahim, when you deal with the constitutional question, this is an essentially political question. You cannot be intimidated into handling it as if politics is the preserve of politicians who think cyclically in terms of 5 years and think about their partisan interests. You, as lawyers, are trained to think in terms of posterity, in terms of our life, our collective life as a country. You, as of necessity, must deal with the question. In conclusion, Chief Justice, in 1803, on a cold, frigid morning of February the 10th, 45-year-old Justice John Marshall and his colleagues in the American Supreme Court, dealing with the question of appointment of magistrates through commissions, made a tectonic statement. It is inherently the province of the judicial branch to state what the law is. The tectonic effect of Madison versus Marbury, which was decided on this day, reverberated all over the world. And the province of judicial review, as we know it, owes its life to this momentous day. The Supreme Court sits on the crest of such a moment. You are being requested to make an intellectually sound and bold decision. We know that you're equal to the task. The country is looking up to you as the Supreme Court. And this court owes the country a duty to do what is right. Equality, justice must prevail. The rule of law. Justice Ouko, that poor child in Maryland will expect you to make a definitive statement that when he or she appears for a public job interview, he or she will not be sacrificed for the reasons of her ethnicity or for the reasons that her father or mother has a small name. In your quest to find judicial truth, we pray that this court remains alive to the history, our history motleyed by corruption, nepotism, malgovernance. The court is besotted to remember our constitutional history and the price that was paid by martyrs who along the way shed blood, the seed of our constitutionalism. Writ large, our national sanity, our joie de vivre has been replenished and remains alive due to a bold judiciary. And every time this court has made bold decisions, our spirit de corps as a country is always reflected. We are happy because from the gloom and misery that we have been subjected by politicians, the courts have displayed sparks of life. And this court will have the occasion to do it again. Please do it again. Do not be afraid. And Justice Patrick Omwenga Kiage, Lord Justice of the Supreme Court, of the Court of Appeal, says that the judge under the Constitution 2010 is a lion or a lioness. You are expected to roar the constitutional truth. You are expected to say it like it is. I have recourse, in conclusion, to a very noble son of Africa, whose text I carry in my hand, and that is Justice Digeng Moseneke, retired Chief Justice of Deputy Chief Justice of this South African Constitutional Court, Professor, University of Pretoria, who says in his book, All Rise, a Judicial Memoir, at page 305 thus: fidelity to our oath of office is important, not because we are important, but without it, it is not us, but our people who will suffer. By our people, I mean the full diversity, poor and rich, white and black, female and male, urban and rural, the marginalized and powerful. All deserve our unwavering protection, which our Constitution demands us to provide. After all, you are the ultimate guardians of our Constitution, for and on behalf of our people. That maxim, that edict by Justice Patrick Omwenga Kiage, the judge under the Constitution 2010, is a lion or lioness. Go ye forth and roar. Roar. Let every corner of this country hear the roar from this court. We submit that all the appeals as standard be dismissed in their totality. Thank you.
Thank you very much, Council, for the submissions. We'll now hear submissions by the last respondent, Kituo cha Sheria 79th respondent.
My humble apologies, Your Ladyship. The 4 minutes will be donated to Kituo cha Sheria.
Honorable Chief Justice, Dr. Kamino is taking a healthy break. I think he'll be here in the next 1 minute.
We can take ours. In that case, then as we wait for Dr. Kaminwa, we will also take a break up to 11.
May I have your attention? Let's be seated so that we start the next session.
It is now the turn for Dr. Camino for the 79 respondents to submit.
May it please the May it please the Honorable Court, I do apologize that when this matter was called this morning, I was not here at all.
It's okay, Dr. Camino.
Thank you very much.
We understand.
Yes.
Yes.
My Lady Chief Justice, it's a very great honor and privilege for me to appear before you this morning. This is my first time to appear before you since you are elevated to the high office of the Chief Justice. My lady, we have known you for many years, and we know what you stand for. We are happy that you are now sitting on that great chair as the Chief Justice of the Republic of Kenya. And may I point out also respectfully that your deputy is the Honorable Lady Justice Mwilu. Lady Justice Mwilu, we remain proud of you. We remain very much having high regard of you for the courage and the boldness and the difficulties that you have gone through. But you have stood firm, and you'll go down in history as a great woman. My Lady Chief Justice, may I say something to you that in our history as a country, there was a lady called Wangua Wamakeri. Wangua Wamakeri was a very courageous woman. She rose to a position, or a political position, within the Kikuyu community. And the men feared that she treated them very badly. To such an extent that the men took an oath and said to themselves that never again shall they be ruled by a woman. My Lady Chief Justice, we still have some people within our own society, particularly men chauvinists, who seem to think that you may turn out to be like a Wangua Wamakeri. They fear that you may probably not be someone who will listen to them. But we who have known you for a long time, we know that there's no way you can become Wangua or Makeri. You will treat men and women gradually. The Honorable Lady Chief Justice, yourself and your deputy, you join Club of Great Women of Kenya. You join women like Mora of Kisii, who fought the colonialists very energetically. Lately, the two of you join great women like Professor Wangari Maathai, whom I had the privilege to appear for in court, represent her in many cases, a very bold woman who was tortured, but she stood firm, and she deserved to get the rank of, to get the prize of a Nobel Prize as the first African woman in this country. My Lady Chief Justice, I would like to mention one or two people who have not been mentioned at all. I think that it's appropriate that we should mention our first Chief Attorney General, the Honorable Charles Njonjo. He had his own shortcomings, but it's not appropriate for us, according to the African custom, to emphasize the shortcomings that he had at all. But he was our first Attorney General, and he was Attorney General for about 21 years. But one thing that he stood for, and which we shall remain grateful to him as a community and as a country, in that he was able to preserve and stand for the sovereignty of our country. At that time, the country was going through a very difficult time. We had coups all over Africa. People who wanted to secede from the Republic of Kenya and go elsewhere. Some of our neighboring countries were making claims to our borders and so on. But he stood firm, and he was able to protect the executive, to advise the executive, and we were able to preserve the sovereignty of the country. We must remain grateful to him. I would also like to mention two other people. I mentioned Zamba Kitonga, who was one of the first chairman of the Constitutional Review, a great Kenyan of impeccable character and integrity, but it's unfortunate that he is no longer with us at all. I would also like to mention Professor Yash Gai, a very great son of Kenya. He is the one who has developed constitutional and public jurisprudence in this country, perhaps more than anybody else. We stand grateful to him. He is still alive. I haven't been able to meet him for a long time, but I'm told that he's in Kenya. He is living in Nairobi with his lovely wife, Professor Cottrell. Now, if you may permit me to come to why we are here this morning. My lady, I will repeat what I said on my opening words before the Court of Appeal. I will repeat to you. As a country, we have been extremely unfortunate in that we have had a poor crop of politicians. The first crop of politicians that we had in the country measured very favorably with world leaders, with world politicians like Gandhi, like Kwame Nkrumah, like Nehru, and others. That was Mzee Jomo Kenyatta and his colleagues in the first government, people who fought for independence. They had grand ideals for this country. But then thereafter, after their demise, we have now current politicians, and there's very little really to admire them for. Recently I said in Court of Appeal that most of them, you get the impression that they are job seekers, they are office seekers. And they come up with things like amendment of the Constitution because they want to continue to be in power. They don't seem to have really much that they can offer the country. Now, I would like to emphasize one thing, my Lady Chief Justice. To look after a country, you must have a creative mind. That is very important. You must have a creative mind where you are able to come up with ideas that can be able to rule the country. And whenever you have a poor politician who runs short of ideas, the immediate thing that he will tell you is that let us amend the Constitution. And that is what precisely happened with the first Constitution. It was amended many, many times, to such an extent that it ceased to be a Constitution. It was not better than a toilet paper at all. We were not proud of it at all. And some of the problems we have at the moment is because of the frivolous amendments of that Constitution that was now overthrown by the 2010 Constitution. Now, there has been a lot of talk about basic structures. I do not wish to dwell very much to go into what has already been said by my very able learned friend. And at this stage, probably I should mention my able learned friend, Mr. Harvey. I thought he did a very good job. He opened the case very well, and he exhibited the impression that he is a person who is very well read and has read the brief very well. I do not wish then to go into a lot of details at all. And I may point out at this stage, my Lady Chief Justice, that should I try to repeat myself, I would have no objection if you tell me that, Hamino, we have already heard that, move on to something else. Now, I will refer you to the Constitution of Kenya straight away. May I refer you to the preamble? The preamble of the Constitution of Kenya is very important when you are considering the question of basic structures. Acknowledging the supremacy of the Almighty God of all creations. My Lady, may I pause there? That first sentence, acknowledging the supremacy of the Almighty God of all creation. My Lady, it shows that there is something above the Constitution, written Constitution of Kenya. It brings in the concept of natural law. And if any amendment or any proposed amendment is against the supremacy of the Constitution, the supremacy of the Almighty God, that amendment must be struck out. It's a higher law more than the Constitution or the other written words that we find in the Constitution. Honoring those who heroically struggle to bring freedom and justice to our land. Again, that reminds us very emphatically that we should not forget the history that this country went through at all. Dirty and rotten history of assassinations. People having to fly from this country. Of the Nyayo era. And at this stage, I may probably My Lady Chief Justice, I've got the book here. A sad book. We lived to tell the Nyayo story. I am almost crying. These were people who were tortured, who slept in cells with water. Some of them thereafter died immediately. They were not fortunate to live as long as Hamino is living at all. They could probably have lived much longer. We have them here. It shows the history of Kenya. My Lady, we should never forget the history of this country. And I'm afraid to say, my lady, we still have elements within our society, within the Kenyan society, and strong, they would like to take us back to those days of the Nyayo era. We had people leading the country, great minds. My contemporary at the Lions School, Nganga Thiongo, living in America. He cannot live in this country at all. Alamin Mazrui, living in America. He cannot live in this country at all. In brief, I'm making a point to you that the constitution that we have at the moment was deliberately made unamendable. Was deliberately made unamendable. And I refer you in this case to the book called Unconstitutional Constitutional Amendments, Unconstitutional Constitutional Amendment by Rosenai. I refer you to page 258 of that book. Page 258 of that book. It mentions Kenya. And it says Articles 255 to 257, different procedures for different provisions. The heading is that these are provisions that are, although they are provided for in the Constitution, but they do not have the force of law at all because they cannot be properly interpreted by the courts at all. So I'm taking the position, my Lady Chief Justice, that the Kenyan Constitution, if you read it very carefully, the entire Constitution, it seems to have been drafted in such a manner that, strictly speaking, this Constitution is not amendable at all. The idea being that if you allow people to amend it, that we shall, within a short time, not have a constitution at all. Now, if I may now take you over you to take the court to the preamble again. Proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation. My Lady Chief Justice, that is where one of our problems we have. That is one of the problems we have as our country. And I refer you to a little book that I have. The book, the title of it is Making Constitutions in Deeply Divided Societies. Making Constitutions in Deeply Divided Societies by a lady called Hannah Lana. Making Constitutions in Deeply Divided Societies by a lady called Hannah. And I will read only, with your permission, I read only 2 words or 3 sentences. Nearly 190 national constitutions are in force today. More than half of them have been written or rewritten in the past 3 decades. Many of these constitutions begin with some versions of the famous 4 words, "We the people." Now, my Lady Chief Justice, we the people, are we really a cohesive society? We are tribes. Our political parties are tribal political parties. They share jobs in advance. Jobs are given according to what tribe you are. Whether it should be that, it should be that, and so on. We are already tribes. So we have a problem. We cannot speak of a society or a community that is cohesive at all. And we are only kept together as a nation by the 2010 Constitution, amended some sections, parts of that Constitution. the inevitable result will be chaos in the streets of Nairobi, chaos in the streets of Mombasa, chaos in our provinces. We need to nurse it. We need to nurse our constitution so that we will give it opportunity to be fully implemented and to grow. In other words, my lady, what you have to do when you are making any decision, you must exercise restraint. You cannot just go out and allow politicians to say they want to amend this constitution at all. First, to make it was a big job, was a very difficult job. Now, it's better that we keep it as it is. There are some individuals, for instance, who have come up with a bill. They suggest that we should have a president and deputy president, and then prime minister, and several other positions. These are intended to create jobs for people whom you can actually call tribal leaders in the country. And the small tribes will be discriminated against. The majority will discriminate small tribes of the country. Let us not buy the idea when they tell us that we shall have a more stable society, a more cohesive society, if we implement we implement the bill by giving jobs to certain individuals. We shall be entrenching tribalism, ethnicity in our society, where you have only certain communities that have been given certain jobs or certain positions in looking after the country. Permit me to go further. There is a respect for environment, which is a good idea, and there is a committed to nurturing and protecting the well-being of the individual, the family, communities, and the nation, which we stand for. Recognizing the aspirations of Kenyans for a government based on the essential values of human dignity, equality, freedom, democracy, and so on. And then exercising our sovereign and inalienable right to determine the form of governance and so on. The point is that this preamble is actually like the ideology that the country stands for. In interpreting Kesavananda case in India, their lordships, the judges, relied on the preamble constitution. The preamble to our constitution is very important. We cannot afford to ignore it. And in this regard, may I refer you to the authority that supports the submission that I'm making to you. Sorry, my lady, I cannot find the book very quickly, but I have a book that has been written by one of the authors in which he is emphasizing that the preamble can be relied upon in interpreting the Constitution. I may Yes, I found it, man. Hidden itself. I'm referring to a book called Interpreting Constitution, a Comparative Study. Interpreting Constitution, a Comparative Study, edited by Jeffrey Goldsworth. Interpreting Constitutions, a Comparative Study, edited by Jeffrey Goldsworth. And it says this at page 247. The court, that is the Indian court, the court has used the preamble of the Constitution as a basis for articulating the basic structures of the Constitution. That is a preamble. The preamble, the court has used the preamble of the Constitution as a basis for articulating the basic structure of the Constitution. And may I refer to the same book before I lose it again, at page 265. And with your permission, let me read it to the Honorable Court. Despite its shortcomings, that's the Indian Supreme Court, the court can be proud of its record. The main responsibility for defending constitutionalism in India has fallen on non-elected authorities. May I pause there? There are some individuals in the streets of Nairobi who may say, why should the judges have such power? Why should the Supreme Court have such power? Why should the Court of Appeal have such power? Why should the High Court have such power? Because they are not elected members of society. But the learned author is telling us this, that the power to amend, the power to guard and look after the Constitution in India is no longer with the elected members. It is no longer with elected members. May I again read this provision very shortly. Despite its shortcomings, the court can be proud of its record. The main responsibility for defending constitutionalism in India has fallen on non-elected authorities, such as President. President of India is not elected, the Honorable Chief Justice. The Election Commission, the National Human Rights Commission, and the judiciary. So the point I wish to emphasize to you is that you do not have to be shy to make decisions at all. The fact that you are not elected people is neither here nor there. You are a powerful institution that should protect our 2010 Constitution. It goes on, the Supreme Court, as the apex court with the power of judicial review over all other authorities, has shouldered the heaviest burden. Its assumption of power to review constitutional amendments, which our law also provides for. You can review the constitutional amendments, has made the most powerful court in the world. My Lady Chief Justice, we want this Supreme Court to be the most powerful court in the world, to be the most powerful court in East Africa, to be the most powerful court in Africa. May I again continue? Has shouldered the heaviest burden. Its assumption of power to review constitutional amendments has made it the most powerful court in the world. It has evolved from a timid positivist court into a very activist one. Its more prominent policy-making role has stemmed from its expansive interpretations of fundamental rights and directive principles, and its liberalization of procedural rules governing access to justice. Through its development of that role, the court has earned widespread legitimacy, which has helped to ensure that its decisions have been generally obeyed. My Lady Chief Justice, now that you are sitting on that chair of power, we are asking you respectfully that you give interpretations to the law, to give it interpretation to the Constitution, so that this case or this Constitution or this court becomes the most powerful court in this country and outside this country. My Lady, I've just been reminded by my junior, Valentine Khamenei, that I've only 7 minutes to go. May I say with respect, I know that you have been giving people 15 minutes or 10 minutes or so on, but if I may say with tremendous respect, I usually think that I have a creative mind, and I can say quite a bit, not for selfish reasons, but I can say quite a bit that can help in shaping the jurisprudence of the country. I ask you very respectfully that you extend my time, that you do not give me only 15 minutes or 20 minutes to address you at all. You give me a little bit longer than that. I think that I can make a contribution to the jurisprudence of this country. My lady, you remember I talked about the sad history of this country. May I make a reference to 2 books only? I would refer you to a book called Kenya, A History Since Independence by Charles Hornsby. Kenya, A History Since Independence by Charles Hornsby. Charles Hornsby, my lady, has got a Doctor of Philosophy in Kenyan politics. And in his book, he sets out the serious shortcomings that the society, the country has had. I will refer you also to another book, which is written by Daniel Branch, Kenya, Between Hope and Despair. The title tells you a lot. Between Hope and Despair, between 1963 and 2020. No wonder that our former President, Kibaki, a very learned president, when he was being sworn in, he said that he was inheriting a seed that had caused misrule for a number of years in the country. I will also refer you to Article 2 of the Constitution, supremacy of this Constitution. Supremacy of this Constitution. It's my humble submission that just from these 4 words, supremacy of this Constitution, one can state that the basic principle applies in Kenya. Supremacy of this Constitution. What that means that anything that is in conflict with the supremacy of the Constitution must be declared void, null and void. And it's significant, my lady Chief Justice, that Article 2.5, the general principles of international law shall form part of the law of Kenya. International law also limits the power to amend. My lady Chief Justice, I refer you to Article 5, Territory of Kenya. I was reading the submission of our very able Solicitor General that he gave this court. And according to him, the basic structure doctrine does not apply. I have known the Solicitor General for a long time. As a bar, I had the privilege of arguing case against one another, and I found him to be a very able lawyer. But this time I must say to him that when he says that the basic principle does not apply in Kenya, he is saying so with his tongue in the cheek. He is not being sincere. He is not being honest. My Lady Chief Justice, if I may remind you, we have problems with the maritime boundaries down at the coast. And the Kenyan authorities, on advice of the Solicitor General, told the ICJ, the International Court of Justice, that this matter cannot be adjudicated upon at all. They were right. I supported them. And you know, they were relying on the basic principle which is contained in this court, in this constitution. And Article 5 says, Kenya consists of the territory and territorial waters comprising Kenya on the effective date, and any additional territory and territorial waters as defined by an act of parliament. This is an issue that cannot, any court cannot sit and make a determination upon at all. And they were right. It is a basic principle that the Solicitor, Airport Solicitor General advanced to the ICJ or advanced to the lawyers that let us not go to ICJ. We shall be wasting our time because this is a matter that cannot be litigated upon at all. May I refer you again, very respectfully, to Article 143, protection from legal proceedings. That is the President. Protection from legal proceedings by the from legal proceedings. This with respect to President. Article 143, Article 2. Civil proceedings shall not be instituted in any court against the President or the person performing the functions of that office during their tenure of office in respect of anything done or not done in the exercise of their powers under the Constitution. It is my humble submission, my lords, that if the President is not acting within the law and is not acting within the Constitution, it is actionable. He will be doing so at travers the Constitution. And
Dr. Kamino, how much more time do you need? Your time is up, and we have a lot more work to do. Could we give you another 10 minutes?
Oh, 10 minutes. Okay, I'm most grateful.
10 minutes.
I'm most grateful. 10 minutes, I'll finish.
Yes.
My lady, I'll finish. Yeah. And then, my lady, I refer you to Article 259, which deals with the construing this Constitution. Yeah. Particularly Article 3, which says, 259.3, every provision of this code shall be construed according to the doctrine of interpretation and so on. That's so much I can do. My lady, may I draw the court to this provision, the Article 38. Article 38 of the ICJ. Article 38 of the ICJ. According to this article, Article 38, my lady, provides, Article 38 of the ICJ provides for the sources of international law, and it is my humble submission that the sources of international law include decisions made by national courts. And the national courts in this particular principle of basic structure have held in Asia, in Africa, and in America that the basic principle applies. Basic principle is therefore no longer debatable, is a source of international law, and it can be enforced by virtue of Article 38 of the ICJ. I'm quoting this from Brownlee's Principles of Public International Law. I would refer you to a book called The Changing Structure of International Law by Professor Friedman, Professor of International Law at Columbia University. And in his book, at page 153 to page 159, he refers to international constitutional law. international constitutional law. International constitutional law, my lady, involves cases like the basic fractures, the Casablanca case. Regarding the misrule, I'm relying on the book authority called Democracy by Condoleezza Rice, which is to be found at page 216 to 217, where he emphasizes or where he sets out what former President Kibaki said when he was being sworn in. Already, we have filed authorities for Kituo cha Sheria. We have filed written submissions. We rely on the legal authorities. We rely on the submissions that we have filed. And I invite you very respectfully that you uphold the decision of the Court of Appeal. You uphold the decision of the High Court, and you hold that basic principles apply, and the President does not enjoy immunity at all. With those remarks, I say to you, thank you very much. I'm sorry I've had little time. I would have liked to talk more, but out of respect for the court, I should obey what the court says. Thank you very much.
Thank you very much, Dr. Kaminwa. We also celebrate you and honor you for the work you have done in the profession. You have mentored many, many lawyers, and you have really defended the Constitution and the rule of law all your years. And for us, you remain our symbol of unity in the legal profession. So thank you very much. We appreciate you also. So this time now, I will ask my colleagues to seek clarification from the submissions so far made by the third appellant and all the respondents who are opposing the first and second appeal. Judge Ouko.
Thank you, Judge President. Thank you, Counsel. I've got a couple of questions and clarifications. I'll start with Mr. Harvey. Once again, on basic principle, basic structure, would you say that the holdings of both the High Court and the Court of Appeal give sufficient guidance to the citizens of this country on how to go about this? Does it tell them what provisions are secured, which provisions will not offend the basic structure? Because looking at the decision by the High Court, it seems that from the preamble to all the 18 chapters, including the 6 schedules, are no-go zones. The Court of Appeal affirming them, but with a bit of modification, seem to say that the entire Constitution actually says the Constitution itself and all that it contains. Same court seems to suggest that yes, there is basic structure, but it's codified or enacted in 255(1). And that for you to touch it, you must go through some 4 sequential steps. But these steps are not spelled out by the court. So the question is, have we guided as a judiciary, as courts, the citizenry sufficiently to know how to go about this in future. The second one is related to the 4 sequential steps. What is the basis of this? Is it part of the procedure contained in Article 255, 1 to 11? Is that can we find it there, these 4 sequential steps, or is it something we picked from somewhere else? That will be it for Mr. Harvey. My next question is to Ms. Kituku for Muhuri. The attention of the High Court, and I believe that of the Court of Appeal, was drawn to the fact that there are certain actions that had been taken by IEBC by the time they were being told that they were not properly constituted. For instance, there were 30 by-elections that had taken place, and I dare add that even the election of the President of the Court of Appeal was done during this period. What is the status in law of these actions that were taken when you said the commission was not properly constituted? My lady, that's all from me.
My first question goes to Mr. Murare Omoke, as well as I think Ms. Angawa and perhaps Ms. Kituku, who talked about the quorum and the issue of minimum and maximum membership in the commission. In the Constitution, there are express provisions for quorum, for Parliament, for the impeachment of the President, for the Supreme Court, and when you come to the chapter on the counties, the legislation for counties must provide for quorum. Then there are other institutions or agencies like Cabinet, like the commissions, where they prescribe a minimum and a maximum. This is different from quorum. You seem to suggest that quorum ought to be read in to the Constitution, whether or not there is legislation. My question then would be, for what purpose then has the Constitution stipulated a minimum and a maximum? What is the purpose of putting in a minimum or a maximum? What do those words mean? My second question goes to Mr. Ongoya. You know that this matter has come to us as an appeal as of right. And I wasn't sure that, it seems to me that you're suggesting that where there is a question of constitutional interpretation, which is pegged on the actions of a state agency or body, then we, on second appeal, would be bound by the rule of factual limitation. On a constitutional question, constitutional interpretation, I just wanted you to clarify that. Finally, to Ms. Kituku, you've suggested that the IEBC, the public participation was not enough, the use of the website. What would you be suggesting could be a method that the IEBC could use in order to reach the Kenyans who you say were not reached? Secondly, I wasn't clear. You talked about evidence that there is no participation in county assemblies. Then you said that the county assemblies have not participated in this case. I was hoping that you could perhaps point to us on record the evidence that shows that there was no participation at the county assemblies, just to clear up the point you're trying to make. Thank you.
I think I can follow that up by seeking clarification also from Ms. Kituku on the question of public participation. And we all recognize that there was no legal framework to guide the process of public participation. My question is, in the absence of this legal framework, does the Constitution allow some broad parameters that can be used for public participation? And if so, what are they, and how can they be measured? The other one is also a follow-up, maybe to Dr. Kaminwa, and this is about the basic structure. I'm happy you are now calling it the principle, because I've been wondering in my mind, when does a doctrine become a doctrine of general usage under the common law or under the international law? But now you say even judgments from the Commonwealth can be elevated to the same level as the international law that is applicable in Kenya as per Article 2(5). Those principles are jus cogens, known as jus cogens. I'm wondering, at what stage does a judgment of the court get elevated to that status? What does it go through to be elevated to that status of a principle of general application under the international law? And I'm looking at the case of Kesavananda, which was before our Constitution, and wondering whether it had actually informed our Constitution because of the preamble, the Article 2, and the Articles 255 to 257, and other articles on human rights. That would be my clarification on that. Judge Wajara.
Thank you, Council, for your submissions, which will go a long way in aiding us to arrive at a reasoned judgment. Yesterday you consistently appeared to draw a distinction between amendment of the Constitution and alteration of the Constitution. And then you did state that when it came to the Constitution of 2010, the word alteration disappeared. Did it just disappear? Or could it have been the intention of the framers of the Constitution? And why do you think it disappeared? And if it did disappear, independent of the thinking of the framers, how would this court resuscitate it in a constitutionally interpretative manner? Then all of us, I think, have been told about the 4 sequential steps which would then legitimize any intended amendment to the Constitution. And I think, Mr. Awi, you can again weigh in on this one. The idea of constituent power, where and how do you locate the juridical form of such constituent power? And then finally from me, I go back to ETOPS. Let's get back to ETOPS. I have a feeling it could become a doctrine in future also. So this is then Ms. Angawa and maybe Ms. Kituku. Let us, for purposes of argument, say that Parliament, in conformity with the minimum of the composition of IBC of 3, that Parliament, for the sake of argument, enacts a law to give effect to that minimum, and indeed sets the composition of IBC at 3, and goes ahead to set a quorum of either 2 or 3 on the basis of that minimum, would that be bad law? That's all from me.
Thank you very much, Mr. Lesinko. If I heard you correctly, you said that the Indian Constitution protects eternity clauses from amendment. Where is that law that says so? What are these eternity clauses? Because if you look at Article 368 of the Indian Constitution, Parliament can amend any article of the Constitution, including 368 itself. But there's a procedure set out in 368. Interestingly, in fact, in India, no court can attempt to challenge, can attempt to overturn any amendment by the legislature, including the state legislature. So where do you get this? What are these eternity clauses that you're speaking about that are not amendable? Where do you get that from? Mr. Harvey, in follow-up to the questions by my two colleagues, at paragraph 1289 of Kesavananda, the judges are saying the history of India and learning from experiences of other countries have endeavored to make their constitution as precise and as detailed as possible so that one need not depend upon judicial interpretation to make it survive. Correspondingly, they made it flexible so that there is need for amendment can be done. In that context, looking at Article 255, and I borrowed this question from Senior Counsel James Orengo. If indeed Article 255 does not contain clauses that would not require amendment, and that under 255 you can actually amend all the clauses, what other clauses, what other matters, because 255.1 refers to matters, and I'm asking myself the question, under 255, it says if the amendment relates to any of the following matters, then those matters must be taken to a referendum under 255 or 256. Now, what are the matters outside the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, national values, Bill of Rights, term of office of the President, independence of the judiciary and commissions, functions of Parliament, devolution, and in fact, the provisions of Article 255? What other matters would you foresee as not requiring an amendment through a referendum, to which we must then defer to the primary and constituent power? What sort of matters are we thinking through? So that, because it's not enough to say, let the courts decide. We must understand as judges, as we sit here today, there are certain matters that you're saying are reserved for us. What matters are those in your thinking? Mr. Dasa and Ms. Kituku, the questions have been asked by my colleagues about Article 250 sub Article 1. But I want to reiterate the question by putting it this way. No provision in a constitution like ours is placed in vain. So that I think in answering my colleagues' questions, tell us as a constitutional question, what is the purpose for 250 sub Article 1? I had arguments that IEBC can do some matters administratively. IEBC can do some matters as a matter of constitutional mandate. Now, explain to me what it can do under 250 sub Article 1 with the minimum of 3. Thank you, Chief Justice.
Thank Thank you. I think we'll follow the practice of giving you 3 minutes to respond.
My Lady the Chief Justice, I have 3 questions. They cannot humanly be answered in 3 minutes. I'll suggest I answer them effectively because they are important to this clarification. My Lord Justice Ouko, you've asked, did the High Court or the Court of Appeal provide with exactitude the location of the basic structure doctrine? The answer is yes. And both the High Court and the Court of Appeal said, for you to identify the basic structure, you must look at the history beneath that particular article. Over and above the history, examine the text. Take, for instance, the judiciary. How did it migrate from the judicature to the judiciary? Because before the judiciary, the judicature was a department of the executive. To that extent, therefore, for you to locate the basic structure, you must confine yourself to those 2 fundamental guiding points. I will give you an example. Nelson Harvey here is male, is a human being. He was born whole. To use the Bible verse in Genesis 1, and God looked at him and said, behold, a perfect being. I can lose a limb. I'll be given an artificial limb to make myself better. I can lose my sight. I'll be given glasses to make my sight better. But if you dismember me negatively by separating the limbs, the lower limbs and the torso, I will die. And if I'm to be succeeded, then I'll have to be replaced by somebody else, perhaps Nelson Harvey II. Essentially, that is the best and simplistic understanding of the basic structure. You will not give me a pig's heart to make me whole. I will live for 1 month and die. So I think to that extent that question is satisfactorily answered. Now, the 4 sequential steps, are they located in the Constitution? No, they are not located in the Constitution. Why are they not located in the Constitution? Let me use myself as the example. I was born. I will die. The manner of my death is not known. Perhaps I will die in my sleep. Perhaps, and to use Professor Githu's words, I will be assassinated because in my status I cannot be murdered, I can only be assassinated. Perhaps I'll die of ailment. So you cannot define with exactitude the manner in which the Constitution will end. Therefore, if you see all these Constitution, the 2010, I believe, I'm not being asked to stop. The 2010, the 1969, and the 1963, they do not provide for their manner of end. But when you look at the 2010 Constitution, you will see it repealing the 1969 Constitution. Those 4 sequential steps, you will trace them from the writings of Professor Nubweze. I can categorize them as primordial, as the imperial creation. You cannot find them within the body. Let me give you another example from the Bible. Trace the genealogy of Jesus in the book of Matthew, Luke, or Mark. You will see it sequentially taken back to Joseph, to David, and finally to Abraham and Adam. Beyond Adam, it is the Creator which is outside the being. And it is these basic concepts that must be read into the basic structure, doctrine, etc. And if there is a contradiction that may be introduced into this argument, let's go back to the being. There are 2 principles. One, we came into existence by creation. We'll follow the genealogy up to Adam. The other one, we came here by evolution. Whichever avenue you pursue, you must go back behind the being. And that is what we call the primordial power, insofar as the constituent power is concerned. Now, constitutions are peculiar to France and the United States of America. These are the two countries that said will henceforth not be governed by an emperor or the King of England, but will formulate a way in which we'll govern ourselves. We'll set up a constitution with three fundamental organs: the executive, the judiciary, and the legislature, so that these functions will not be left to a monarch. Dr. Smokin Wanjala, you've asked, how did the word altar disappear? Was it deliberate? And what do we do about it? It is my answer that the disappearance of the word altar was premeditated and deliberate. And if you look at the writings of Professor Nobweze, he says the fundamental changes to the Independence Constitution were permissible because of a flaw in the definition of the word altar. So that flaw has now been corrected. So that you will not graft an antelope on me and you say you have a being. That is the intention of the framers of the Constitution. And the court ought not to resuscitate it. Because if you do resuscitate it, you will have created the mode of death of a constitution. And that is not what the framers of the Constitution intended. We've gone back to tracing the origin of the constituent power. Does it have a juridical form? The Pharisees asked Jesus, when will we know the end of time? We will never know the end of time, but you will see the signs of the end of time. That is what the teacher said. Now, Aaron Ringera has given clarity to this matter in the case of Njoya versus the Attorney General at page 677. This is what he said. Indeed, it is not expressly textualized by the Constitution. And, of course, it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they will do so only ex abundanti cautela. For instance, I was born here in Kenya. I need not to have an ID or passport to use the terms of Miguna Miguna for me to be a Kenyan. The ID and passport is there for formality, and it is from that premise that we must perceive the constituent power. Justice Lenaola, you've referred to the Casavananda case, and you've asked us to create a clarity of where these other facets of the basic structure reside outside 255(1)A to J. Now, that is the reason as to why they have to be basic. When we were in Musingu, Ongoya went to study power mechanics, and because I didn't have greater qualification when I joined high school, I studied art and design. But there is a dichotomy between a diesel engine and a petrol engine. There is the carburetor and the injector pump. And if you doubt this difference, if you attempt to kick it like a stone, you will not travel. It is as simple as that. Now, what is the foundation of a democratic state? The foundation of a democratic state is based upon the social contract, with the trichotomy of parliament, judiciary, and the executive. And if any of those two are fused, then you are obliterating and obscuring that dichotomy. And I can say affirmatively, from my limited learning of the law, that the basic structure must of necessity include the executive, the judiciary, the legislature, and the Bill of Rights. Because for the Englishmen, they said, oh, King, no, you cannot rule us like this. We must have the Magna Carta for us to have terms of engagement. For the French and for the American, they said, we must have a written constitution. And for that, the king will not be the legislative. The king will not be the judiciary. And will have rights, rights that you are not giving us, rights that inhere in us as being. To that extent, therefore, those must be entrenched and respected as the basic structure, which can be discerned outside 255, 1A to J. I believe I've done my part, or if there's a follow-up question.
Yes, you took your time, 9 minutes.
My lady, time is not of essence here. This is a serious enterprise.
Yes.
The Supreme Court only sits once after 5 years to determine an election petition. What is the hurry? Where are we going to?
Yes, thank you.
Good morning. My lady, the Chief Justice, my lady, the Deputy Chief Justice, my lady and my lords, Justices of the Supreme Court. Your Lordship, Your Ladyship, Justice of the Supreme Court, Njoki Ndung'u, you have asked for Parliament to conduct business for this court to sit. That's at Article 121 and Article 163(2). There is no express provision for quorum of the IEBC and indeed the other independent commissions that are established under Chapter 18 for the basic reason that the Constitution provides for the compositions, the commission's minimum and maximum composition. It does not provide a specific number of composition under the Constitution as it does for this court, which is 7, and it does for Parliament and for Senate, because those are specified in the Constitution. Hence, the ability for the drafters of the Constitution to set the quorum as they intended during the drafting. Now, what is the purpose of the minimum and maximum? And I think that is related to the question that has been asked by His Lordship, Dr. Wanjala, and His Lordship, Justice Isaac Lenaola. The engine, the two engines that I spoke about, the Constitution and the statute. The Constitution did not specifically provide for the set number of commissioners. It therefore could not provide for the set number in terms of quorum. That is why the Constitution, under 88(5), says that the Commission must operate on the basis of the Constitution and the legislation. And in the legislation, Parliament, in its wisdom, sets the composition as it did, currently at 7. And set the quorum in the schedule at paragraph 5, whose deletion or repeal or declaration of unconstitutionality is core to the dispute before this court. And I will clarify for my lady, Njoki Ndung'u, Justice of the Supreme Court, that it was not my suggestion, at least not to my recollection, that we need to read quorum into the Constitution. That seems to be the implied suggestion from the submissions of the IEBC, that we should read the minimum of 3 as the implied quorum for the Commission.
We will give you another 3 minutes, but please don't rehearse. We have what you send in the submissions. Just stick to answering the question.
Thank you, my lady. That was the IEBC's submission. Our submission is that you cannot imply quorum based on Article 251, which provides for a minimum of 3. His Lordship Dr. Wanjala asked if Parliament in its wisdom sets the composition as 3, which is the minimum provided for by the Constitution, and sets quorum at 2. I disagree that it could set quorum at 3 because that would be a unanimous decision, and quorum is the minimum number required to make a binding decision. Would that be bad law? If Parliament in its wisdom did that, went through the legislative process, gave an opportunity for public participation, had the views, and did that, and no one challenged that constitution of 3 in a court of law, and there is no decision of the court that finds it to be unconstitutional, then it would stand as good law. But as we speak, the section that provides for the constitution of the commission has not been changed. So quorum cannot be a minority of that set composition. And I would like to end there and bring to this court the current situation. If you were to take the submissions of the IEBC and confirm or put it as the position in law that the quorum can be 3 because the composition can be 3 as set as a minimum in the Constitution, what you will be saying is that the Commission, as currently composed by statute, would be bound by a decision of the minimum membership. But what is most important, my ladies and my lords, is that alongside the declaration of unconstitutionality of paragraph 5 of the schedule was a declaration of unconstitutionality of paragraph 7 of the schedule, which said that where a unanimous decision is not reached, then the decision of the majority of the members present and sitting would hold as a decision of the Commission. As it is now, therefore, there is a lacuna, if you were to take the arguments of the Commission, in the law on that question, so that we are going to a point where 3 commissioners will say our decision can bind the Commission, whereas on the other hand, 4 commissioners would say we are the majority, our decision ought to bind the Commission. That is the risk that we are at, because the flight went so far away from the flight path with 1 engine and passengers inside it. Do not forget that. I urge this court not to forget that. We will have that situation, and I do not think it is in the realm of imagination, where 3 commissioners will say, we stand, and 4 say, we stand. Thank you.
The Honorable, the Chief Justice, my ladies, my lords, my name is Justice Njiru Nyaga for the 3rd appellant. And for the sake of clarity, Justice is my name, not my title. I will be addressing the questions that have been raised by the Honorable Judges, starting with the question of Lenaola J as to the purpose of Article 250, sub-article 1, concerning the minimum of 3. Can IEBC do some matters administratively? And the simple answer to that is no. And we wish to seek solace from the decision of the High Court in this matter, where they were explicit that the statute which has been implemented by, has been enacted pursuant to Article 88(5) does not make a distinction between administrative and policy issues. And that is a point of departure from the decision of Biwott, where the Biwott case was saying it is policy issues only. But the High Court distinguished that, and they said that is bad law, and they respectfully departed from that. So our straight answer to that is no. As per the law, they cannot even do administrative issues. To the question by Lady Justice Njoki, what is the purpose of Article 251? In essence, it just defines the composition, the minimum number of members who can compose an independent commission, because it is trite that there is safety in a multitude of councillors. And when you look at the Biwott case, the issue of quorum came up, and it was clearly defined that quorum is the minimum number that is required for a commissioner, for a commission to transact its business. So 251 states the minimum with the Honorable Chief Justice that for, to the question of Justice Smokin Wanjala, if membership is set at 3, and I will be requesting for just a few more minutes so that I also address Ouko's, Justice Ouko's question. May I proceed? Thank you. Concerning the question by Justice Smokin Wanjala, if membership is set at 3 and the quorum at 3 or is set at 3 or 2, is that bad law? We respectfully submit that that will be bad law, having in mind the important functions that the IBC conducts. And when you look at the letter and the spirit of the Constitution, it will be wrong to have important decisions of great magnitude being transacted by only 2 commissioners. So for that, we will humbly respectfully submit that that will be bad law. Concerning the last question by Honorable Justice Ouko, what is the status of the actions that were taken when the IEBC was not queried? We respectfully submit first that what is before this court is not the matters that were taken by IBC, such as even the composition of the court, or the by-elections. But what is before this honorable court is a question of the amendment of the Constitution. However, that being said, we take solace in the decision of this honorable court in the case of Mary Wamboi Munene versus Peter Gishuki Kingara and 2 others, a 2014 decision, where you are very clear as to the effect of a provision of a statute being declared unconstitutional. It can either be retrospective or prospective. Therefore, in this case, for matters which the court will look at and see that this, if we are to apply them retrospectively, they might have serious implications, the court can respectfully decide to have them be prospective. And therefore, we humbly submit that you do not buy into the suggestion that has been given by the Honorable, the former Attorney General, Professor Muigai, who I greatly respect, that in any such case, the default position ought to be the application is retrospective. And that is what the decision, that was your decision in the case of Mary Wamboi. And allow me just to finish with what Justice Kriegler said. And this is what he mentioned. I'll read that quickly in that decision, which this court rightly quoted. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado. Though it's sometimes convenient to have the court to declare it to be so, and every proceeding which is founded on it is also bad and incurably bad. You cannot put something on it and expect it to stay. It will collapse. The default position concerning this matter is that the declaration of an unconstitutional amendment to a statute should be retrospective. And for that reason, paragraph 5 and paragraph 7 of the IBC Act, second schedule, still apply. I hope that I've addressed the questions.
Yes, we have taken the answer. Ms. Kituku.
I will invite now Mr. Topua.
Thank you, Chief Justice. I will start with the question asked by the Honorable Justice Ouko on what would happen to the actions that have already been undertaken by the IBC when it was not queried. To answer that question, I would suggest and say that the powers of a court to issue a remedy upon a declaration are very varied. A court can suspend the applicability of the unconstitutional invalidity either retrospectively or prospectively. When it does apply it retrospective, it saves those acts that have already been done. When it applies it prospectively, it does cure the gap that would happen between the date of the declaration and the date that Parliament would be ordinarily remedy the invalidity. Therefore, in this case, we would suggest on the first aspect to say, number one, that either we apply it retrospectively or prospectively. The actions on Article 257.4.5 were done after the judgment in the Katiba Institute. So it will not have any effect on this. It will not change the status of that declaration. However, if there was no order that was issued suspending the declaration, a party that is aggrieved by that, if no order of suspension is issued, it means that the declaration, although issued in rem, cannot apply to each and every action that IBC did. A party aggrieved by a particular action that IBC did during that period it was not queried must move the court in order to have that declaration applied in that action that that party is aggrieved with. For example, if a party was aggrieved, on the results of the elections of the president of the Court of Appeal, that party must move the court and have that declaration apply in that case. So I refer the court to maybe the example in the Murwateto case, when this court issued a declaration that the death penalty was unconstitutional. It did not mean that every convict who was on the death law was set free. However, that the lower court or any other judge who sought to apply that reasoning in the Murwateto case had to bring it within the confines of the case that was before them. So it does not entirely apply bracketry, but just to be brought within the armpit. My lady Chief Justice, I think I'll be seeking more time. I have 5 more questions to answer from the members of the bench.
Yes, if you can summarize them to answers, please don't rehearse your submission because we have it. Just zero in on the answer.
Thank you, my Chief Justice.
So we are giving you another 3 minutes.
On the issue of public participation, as was asked by the Chief Justice and Honorable Justice Njoki Ndung'u, I will start by saying public participation is a factual issue. It can only be determined by evidence, whether or not there was public participation. The issue was specifically pleaded in the Third Way Alliance case that there was no public participation. None of the parties in the matter brought any evidence to prove whether there was public participation. In the absence of such evidence, then the court did find that there was no public participation. Although the counties had been sued and processed the bill without public participation, did not participate in the proceedings. So therefore, the obvious conclusion would be, in the absence of any evidence, there was no public participation. The issue of public participation was actually not contested. The IBC did not provide any evidence on the issue that was raised by public participation in the in the Superior Court. On the question by the Chief Justice, how should this public participation look like? Ideally, it would be left to the IBC to determine how best to undertake public participation in line with the law and the regulations that exist. Its own procedures, administrative procedures, provided how IBC would undertake public participation in relation to verification and certification, in relation to signatures and Article 257 form. There are many methods that IBC could have done that. At a minimum, it ought to have perhaps provided the list of the supporters to the popular initiative at every polling station for inspection, so that members can have an opportunity to engage with the list. Number two, it could have also used other media services that are easily available to the members of the public. It could have used print media, or television, the radio station, TV, just to popularize that list. And also, it could have done what the Elections Act says, that's what I've said, through physical inspection of the register. On the question again by Justice Njoki Ndung'u, Justice Wanjala, and Justice Lenaola, on the quorum, on why Article 251 and its importance, I will start by saying that we can't find that answer in the CKLC report. The CKLC on the Constitution, there were concerns that sometimes the commissions could have been too big or they could have been too small. So the idea was to restrict the number of the commissioners. And number two, Chief Justice, I humbly request for 1 minute to wind up. Thank you. To restrict the number or provide Parliament with the leeway to set the appropriate number of members, as commissions are different and carry out different constitutional obligations. For example, the Kenya National Human Rights Commission has 5 members set by registration. The National Gender and Equality Commission has 5. The Judicial Service Commission has 11 members. So this is an issue that was left to the Parliament to determine the number of commissioners. So therefore, when Parliament, in its wisdom, which Parliament does not legislate in a vacuum, but Parliament understands and knows the needs of its people, understands its history, when it did set the number of the IBC commissioners as a minimum of 5 and a maximum of 7, it clearly undertook its mandate and understood what it was doing. So that registration that put the number as 5 has not been challenged in this court. It is not on appeal, and we urge the court to find as such. I will associate myself with the submissions made by Mr. Nyaga on the issue of business and policy of the IBC. Thank you.
Thank you, my lady, my lords. Direct the questions. Am I suggesting that this court is bound by the rule of limiting itself to matters of law in case of a second appeal? Yes, that's what I'm submitting, for the following reasons. Article 163 that gives that right of direct appeal, it's a direct of appeal where what is at issue is interpretation or application of the Constitution. In doing that, you employ Article 259 of the Constitution, which provides legal principles. Section 3 of the Act establishing this court, which sets out legal principles. So the matters that we are doing actually application of legal principles to the question at hand, and not an investigation of the facts afresh. Secondly, the case of Munya